Hello, everyone, and welcome to our IP monthly webinar. I'm Yến Phạm from SNO and IP. Today, we will discuss the two main options for registering your trademark in Vietnam, the Madrid System and the National Trademark Office. And by the end of the webinar, we hope you have a clear understanding of the advantages and the disadvantages of each approach, allowing you to make the best decision for your brand protection strategy in Vietnam. The webinar agenda covers the following main points: a brief introduction of our firm and practice, a brief introduction of the IP framework in Vietnam, and how trademark is examined in Vietnam. We're also discussing some statistics about trademark applications filed in Vietnam by the Madrid route and the national route in the last 5 years. And we will provide you with some information about the pros and cons of registering your trademark in Vietnam by each route for your consideration and strategy. So during the webinar, if you have any questions or concerns, please submit your question here or via our email at so-ipr.com, and we will address all your inquiries accordingly at the end of the webinar. Now, firstly, I would like to introduce a bit about our firm. We are SNO IP, a full-service IP firm working throughout the Greater China, the Southeast Asia, and the Eurasia region. We provide our clients with an international standard of service with deep local knowledge, and we can assist our clients in all range of IP matters, including but not limited to IP prosecution, IP filings, opposition, invalidation, appeal, market survey, investigation, enforcement, litigation, and also commercializations. In the Southeast Asia regions, we cover 10 countries with more than 40 IP specialists. In Vietnam, we have offices in both Hanoi, the capital, and Ho Chi Minh City, the economic hub of the countries. And by the way, I'm based in Ho Chi Minh. As for me, I'm a senior and qualified IP attorney of SNO, handling all prosecution work in Vietnam and other Southeast Asia countries. I have more than 15 years of trademark and patent experience, representing our clients in contentious and non-contentious matters, including opposition, cancellation, appeal, trademark portfolio management, and strategic advice. Before we dive in, I would like to brief the trademark system in Vietnam. Vietnam is a member of the World Intellectual Property Organization since the 1976. And we are also a contracting member of several important conventions and treaties relating to intellectual property rights, such as the Madrid Agreement and the Madrid Protocol, the Paris Convention, the Patent Cooperation Treaty, aka the PCT, the Berne Convention, and the Hague Agreement, to name but a few. So here you can see some key principles of trademark examination in Vietnam. First of all, it's worth to note that Vietnam follows the first 5 principles. So when filing a trademark application in Vietnam, it's not required to present any evidence of use or intentions of use of the applied mark. Therefore, it's advisable to file your mark as early as possible to get the earliest filing date. Secondly, a trademark application in Vietnam is go through the formality examination and the substantive examination process. So in the formality examination, the IP office in Vietnam will check if the submit document is in order or not, and especially if the list of goods is acceptable or not. The IP office in Vietnam has a very strict viewpoint in reviewing wording of classification of goods and service. Therefore, it's advisable to check with your local attorney before the filing if the proposed list of goods is ordered or not, to avoid office actions, which may cause a delay to the application. Thirdly, in Vietnam, a trademark will be examined on both absolute and relative grounds. So there are a possibility that your mark is rejected due to devoid of inherent distinctiveness or due to some citation. So a current trademark search before the filing is highly recommended. Last but not least, there are regimes for a third party to raise their opinion against the registration of a trademark in Vietnam. In particular, if the trademark is still pending examination or it will be open for opposition against this application. If the trademark is already registered, you can cancel or invalidate the registration of this mark based on several grounds, including the non-use ground, the bad faith, and the ground that the registered mark failed to meet the protection criteria at the filing time. It's worth to note that once a trademark application is opposed by a third party, the examination process of this application will be prolonged significantly, and the invalidation process in Vietnam also really takes time. Generally, it takes at least 4 years or 5 years or more. Now, let's explore the two filing options in Vietnam. In general, we have the filing by the Madrid System, which is an international system managed by the World Intellectual Property Organizations, allows for trademark registration in multiple countries, including Vietnam, through a single application based on a basic application or registration in a country which is also the contracting party of the Madrid System. And the second option is filing directly with the National Trademark Office in Vietnam. This is a traditional method where you file your application directly with the Vietnamese Intellectual Property Office. Firstly, we want to show some statistics of application filed in Vietnam in the last 5 years by the matrix as the national root for your overview. As you can see in this slide, it includes the numbers of matrix filings and national filing in Vietnam, in which clearly shows that the number of national filing in Vietnam is still dominant. The chart also shows the stability of matrix registration designating Vietnam, while the national application has slightly increased. But despite the overwhelming number of direct trademark applications compared to the Madrid System, the examination efficiency for the Madrid application is likely higher in terms of number of applications examined. As you can see here, the volume of the Madrid application handled each year quite stable and nearly reach the number of applications filed each year. Meanwhile, for national filing, the volume of applications processed varies considerably from year to year, and so quite an unstable trend. When we take a closer look, the numbers show that the processing rate of Madrid application is relatively high, often around 90% and even exceeding 100% some years. Meanwhile, the processing rate of national applications is slightly lower. So, in the next several slides, I will discuss the advantages and disadvantages of the Madrid system, generally and specifically in Vietnam. The general advantages of the Madrid system, regardless of which designated country is chosen, is that it simplifies the process. Only one application filed in one language for multiple countries, so it's really saves your time and resources compared to individual national filings. It's also very cost-effective, especially when you register in more than 5 countries. Another advantage of the Madrid system is the centralized management. Renewals and other administrative tasks, as well as on the formality proceedings, are handled to a single office, namely the International Bureau, and it will save you a lot of time for paperwork and administrative work. However, the Madrid system has also some disadvantages. And the first one is the central attack. That means within the first 5 years period, the international registration remains dependent on its basic registration and application. And if the basic registration or the application is refused or ceased to exist within this period, the international registration, including in own designated countries, will cease to exist too. Secondly, when filing the Madrid application, the list of goods must be the same as of the basic registration and application. Meanwhile, the specific requirements and examination practice for list of goods and service of trademark filing vary significantly from country to country. Therefore, the risk of being refused due to the list of goods is high, and it will take time for the international registration owner to revise the list of goods in several different countries. Last but not least, it's worth to mention that there are restrictions regarding the assignment of an international registrations, as the chancelleries must have a business, be domiciled in the contracting party, or be a national of a contracting party in order to be entitled to own the international registration totally or in part. So apart from the general advantages and disadvantages discussed above, in this slide, we will provide you with a comparisons of some specific procedure involved in processing the Madrid system and national trademark application in Vietnam to help you easily consider the option for filing a trademark application in Vietnam through the Madrid system or directly with the national office. So here, in terms of the examination stage, the Madrid application runs through only one examination stage. The trademark office will review the applications as to formality and substance all at once and issues a provisional refusal notice or a statement of grant of protection. Meanwhile, there are 2 separate examination stages for national applications. The application will be examined in formality, and if there is any shortcoming, the trademark office will issue a shortcoming notice, and you have to respond to the notice and correct any formality deficiency. When the application is accepted as to formality, it will be published and then enter the substantive examination stage. In terms of examination time frame, the Trademark Office in Vietnam has to review an international registration designated in Vietnam within the time frame of 12 months sharp as commit with WIPO. Why? Due to the current heavy backlog of the Trademark Office, the national trademark applications filed in Vietnam as usually reviewed within like 24 or 36 months. So this is a big plus for the Madrid application in Vietnam. In terms of the opposition proceedings, this is available for only the national application and not applicable for Madrid applications. For the opposition proceedings in Vietnam, the Trademark Office needs to convey the opposition petition to the applicant, request the applicant's counter argument, and then review both the opposition argument and the counter argument. So the examination time frame of a national application which is opposed is usually very lengthy. But for both the Madrid application and national filing, the third-party opinion proceedings is available. That means if you think a mark does not meet the criteria to be protected as a trademark, you can submit your opinion against the registration of this trademark. The Trademark Office will consider your opinion as a source of information for their decision if the mark can be protected or not. But they doesn't have the duty to respond to your opinion or convey it to the applicant. The third-party opinion doesn't affect the examination time frame of the international registration designated in Vietnam. So when it comes to response review, the national application has a plus. If your IP application in Vietnam is provisionally refused and you submit a response, it will take at least 3 years for your response to be reviewed and considered. Meanwhile, this time frame for a national trademark application response to be reviewed is usually around 18 months until 24 months. And the next point is about the registration certificate, which is called the certified certificate for an international registration designated in Vietnam, which is available upon request in Vietnam for international registration, but is automatically issued for national trademark applications. Please note that for enforcement action in Vietnam, normally you are required to show up the evidence of your trademark rights, namely the registration certificate, if you want to take any enforcement actions. Meanwhile, it takes at least 4 to 5 months for the Trademark Office to issue a certified certificate for an IR for an international registration upon receiving your request. Therefore, please keep in mind, and it's advisable that after your international registrations in grant protection in Vietnam, you file the request to obtain the certified certificate of the international registration immediately and keep it in your files so that you can be well prepared and ready when it comes to taking enforcement action to protect your trademark rights in Vietnam. And last but not least, with regard to the post-registration proceedings, for the international registrations, it can be done with the International Bureau, which is very fast. But for national application, it will be done with the National IP Office, and the time frame is usually very long, at least 6 months, due to the current heavy backlog of the IP Office in Vietnam. So, which on the information discussed above, we hope that by understanding the advantages and the disadvantages of both methods, you can make an informed decisions about your trademark protection in Vietnam. And this is the three key takeaways. First, we note that the first to five principle is applied in Vietnam and is very important. Secondly, for the international registration, you can consider, depending on the number of countries designated, the actual use of the mark in each country, and thirdly, the Vietnamese specific pros and cons as we discussed above. And last but not least, please consult the local attorney if necessary, so that you have a clear advice and correct advice in a specific case. Oh, during the webinar, we received 2 questions. Now, and I want to share it with you. The first question is, if our international registration designated in Vietnam had been partially provisionally refused, for example, for some goods and service, and I did not respond to the provisional notice, does that mean that our international registration will be protected for the part that were not refused, namely for the other goods and service covered by the international registration, or it will be refused for all? Okay, thank you very much for the question. Here's our answer. If your international registration mark has been partially provisionally refused in Vietnam and you did not respond, technically your mark is protected for the goods and service that were not refused. However, you will need to wait until the Trademark Office issues a final factual refusal and a statement of grant of protection for this part for your trademark rights to be valid. That means only when the Trademark Office issues a statement of grant of protection for the remaining goods and service, then your mark is considered registered in Vietnam for such goods and service. Thank you very much. And now is the second question. If our international registration designated in Vietnam has been provisionally refused due to the list of goods, can we amend or make a limitation of the list of goods directly with the National Trademark Office in Vietnam in response to the refusal, or we need to do this with the International Bureau? Thank you very much for the question. And our answer is that in this case, there are 2 circumstances. In case the international registration owner agree with the request of the Trademark Office, and in the response, we only need to clarify some nature of some goods, or we agree to clear or to limit the items that is questioned by the Trademark Office, then we only need to file a response, and in which we like mentioning our clarification and our willing to remove and clear the problematic items, and no need to work with the International Bureau. But in case we don't agree with the opinion of the Trademark Office, and we want to limit the space of goods or to clear some item, but not according to the suggestion or recommendation of the Trademark Office, and then we need to make the limitation of goods with the International Bureau, and then file a response to the provisional refusal along with the limitation of list of goods with the WIPO. We don't have any other question from you, so we will end our webinar here. Once again, thank you very much for your interest in our webinar. And if you have any question or concern or inquiries, just feel free to send us your concern via email, and we will surely respond to you in a timely manner. So we wish you a happy World IP Day. Thank you.